what we want to avoid in Scotland. Certainly before you know how many regulators you might be dealing with. And I think that's why you've seen the increase in costs initially in England and Wales leaping for English solicitors by 20% this year. That's a cost that's gone on top of their practising certificate fee to pay for those superstructures.
Thank you. Can we now go to and deal with the regulation aspect, which I know to some extent has already been dealt with? Stuart Maxwell.
Thank you, Convener. Before I do that, can I just take the panel back to 39.9 that Mr Clancy mentioned? I've just had a look at it. I'm just wondering, given the need for flexibility for future unforeseen circumstances and changes and adaptations as things progress, if you remove 39.9 from the bill, how would you carry out that ability to change things other than through primary legislation?
Well, there could be another mechanism which could be employed, which is that the approved regulator would be able to make changes to the roles of heads of legal services under the licensing or practice rules which have to be issued by the approved regulator. So that would be one way in which you could change the functions. The other
regulating themselves effectively, though?
No, indeed not, because the head of legal services is not part of the regulator. The head of legal services is someone who is employed by a licensed provider or is a principal in the licensed provider firm. So I think that would be one route to do it. Another route to do it would be to have the approved regulator seek Scottish ministers to make regulations, but that's a different track.
I can see your point in terms of your second option there. I can see the relevance there, and also your points about the Lord President role that you mentioned before. Moving on, though, I just wanted to ask in terms of the kind of regulatory bodies that may be set up by the bill, and whether a fully independent regulatory body, in your opinion, should separate representative and regulatory functions, and that kind of model would in fact better meet the needs of the consumers' interests.
I'll pick that one up. I think there's been a lot of confusion around what this means, the separation of regulation and representation. How we interpret it is how it's set out statutorily, which is for the Law Society, for example, as one potential regulator, to have an obligation to the profession and the public in relation to that profession. That doesn't challenge any voluntary representation that others might have in other ways. So there are bodies in Scotland already. The WS provide terrific support services. There's organisations like the GBA, like the Family Law Association. There are a number that are around that voluntarily are supporting the profession. What I think this obligation on the Law Society as it currently stands on the profession and the public is no different from the responsibility that you would see in any other professional body. So if you look at the Institute of Chartered Accountants, if you look at surveyors, if you look at architects, they all carry an obligation to uphold the integrity of a profession in the interests of the customer it serves. And I think we see ourselves very much as a professional body in that respect. Therefore, at this point, we believe we can be a competent regulator of a licensed service provider in the legal market, as others might too, but we certainly believe that's the case.
You don't share the concerns, certainly, of some of those who have given evidence in writing so far about this dual function, if you like, that would occur if the Law Society, for example, became one of the regulatory bodies?
I mean, we have that dual function at the moment.
No, I appreciate that.
And this is a matter that is from time to time visited within the profession. In the time I've been on the Society's Council for 11 years, and it's been debated periodically. And we've come to the conclusion on each occasion, and when the Parliament looked at this, because there was an inquiry in the early days of the Parliament into the regulation of legal profession in Scotland, that the current situation was, the best available. That you can easily point to flaws with it from the consumer interest, from the point of view of the profession. But in terms of a compromise for a profession of 10,500 in a relatively small country, there was a degree of clarity. When Cathy Kiggy said earlier on, people do understand what the Law Society is, and they understand what role the Law Society holds, and that's an understanding not just within the profession, but amongst the general public. We have an identified role in Scottish public life. The danger is if you fragment all of that, it's not entirely clear as to who actually speaks for the legal profession. And if somebody's got a complaint, not a client complaint or just a general complaint about the legal profession, it's not entirely clear as to where they would take the representations that they would want to make.
Okay,
Can I make one other point in terms of the answer I gave earlier too? This is also an area that we've suggested the bill needs amending, in particular thinking about other regulators that might step forward into a licensed service provider field, and that the bill doesn't at the moment require a level playing field in terms of the compensation side of delivery to customers, and we've strongly said that between regulators there needs to be that commonality in serving both the professional need and the public interest need.
May want to question you further on the sort of level playing field aspect. But just one further question, Convener, and that's going back to something that I think it was Robert Brown who raised earlier in terms of conflict of interest. Is it your view that, and I thought I picked this up, your view that regulation of the, if you like, these conflicts of interest, the best place to deal with that is through the regulatory bodies dealing with it, rather than through effectively the bill itself? Is that your view?
I think that is our view. And what we can say is we can anticipate certain things that will be in our regulatory rules. And one of the fundamental rules that applies to the solicitor's profession at the moment is you do not act in a conflict of interest situation. There are very limited exceptions where family members, etc., are on opposite sides of transactions, but generally speaking. And one of the other absolute golden rules is that your money and the client's money never mixes. The firm's financial affairs must be kept separate from the client's financial affairs, and that the client's money must be guaranteed in all circumstances against business failure, against dishonesty, against negligence. All of these things are likely to be in any regulatory regime that we would propose, and we would hope, I mean this in the end is a matter for Scottish ministers, but we would hope that they would be insisting that all of these things would be in the regulatory regime of any alternative regulator, because we think these are all essential public protections.
I would agree, and I think the question now is effectively beginning to crystallise into how we make sure that is the case. And I think if it is the case that it's done in the way you suggest, how we ensure that other bodies who may want to set up as regulators effectively follow a similar example. And I think that's something certainly I'm sure the committee will discuss in some detail.
There is provision in the bill, Mr Maxwell, for reconciling of different regulatory conflicts between professional bodies, and I think that one would envisage that those provisions would go a long way to meeting that concern.
It also has to be part of the regulatory scheme which is approved. Just to say, to add to what Michael said, to be able to demonstrate how you would deal with regulatory conflict is also to be part of the regulatory scheme that would have to be approved by Scottish ministers before an approved regulator can be authorised.
Thank you. Nigel Dodd.
Thank you very much, Convener. I was going to ask the panel, and good morning, ladies and gentlemen. I was going to ask you about the sort of regulatory burden and your concerns about the level playing field. I suspect everything that you wanted to say has been said. So I guess my question is there anything that in that area that hasn't been said?
Focused on the compensation side. The other side, of course, is the complaints handling, that would be also a common playing field amongst regulators.
Right. Thank you. I think your written submission is probably pretty comprehensive on these things anyway, so I don't want to extend that. Can I then go to ask whether or perhaps why legislation on ABSs is actually necessary? If firms at the moment can get loan capital and protect that by a floating charge, they plainly can employ other professionals. They could do so on bonus schemes and other mechanisms which would give them a significant commercial interest in the firm. Why do we actually need ABSs at all, please?
I've tried to give just one or two kind of practical examples of the sort of things that aren't, provided for in terms of the current market. It's certainly the case. There is a great deal. We are, after all, lawyers. There is a great deal of ingenuity in how things operate. I gave the example of employee share ownership, but certainly even in the smallest of firms, employee bonuses tied in some way to performance or quantity of business that the firm is doing, etc., are common things that are in no sense illegal. I suppose almost we would turn the question back on you, and because this is how we approach this. We approach this to say, is there an ethical difficulty with this further liberalisation of